Hello, I'm the masked amp. I've got a mask and I'm an amp. Section 2 and Section 3 are the sections of the Mental Health Act that are most commonly used when compulsory detention in hospital is being considered. Section 2 lasts for up to 28 days, and its main purpose is to assess a patient in hospital, although it does also permit treatment. Section 3 lasts for a maximum of 6 months and is for the purpose of providing treatment in hospital. The recent Mental Health Act review is, however, recommending that this duration should be reduced to 3 months. Statistics show a year-on-year increase in the use of compulsory detention. In the year 2019 to 20, there were a total of 27,968 admissions under Section 2 and 4,043 detentions under Section 2. That was in England and Wales. The Code of Practice states that Section 2 should only be used if the full extent of the nature and degree of a patient's condition is unclear, or there is a need to carry out an initial inpatient assessment in order to formulate a treatment plan, or to reach a judgment about whether the patient will accept treatment on a voluntary basis following admission, or there is a need to carry out a new inpatient assessment in order to reformulate a treatment plan, or to reach a judgment about whether the patient will accept treatment on a voluntary basis. The Code goes on to say that Section 3 should be used if the patient is already detained under Section 2, or the nature and current degree of the patient's mental disorder, the essential elements of the treatment plan to be followed, and the likelihood of the patient accepting treatment as an informal patient are already sufficiently established to make it unnecessary to undertake a new assessment under Section 2. Despite this guidance, making a choice between Section 2 or Section 3 is a frequent source of discussion among amps. There are a number of reasons for this. Some are strictly to do with professional clinical decisions and the imperative to explore least restrictive options. It may be felt, for example, that the shorter detention period of a Section 2 is felt to be less restrictive than the 6 months of a Section 3. Some may be more to do with expediency or, shall we say, complex issues. So, what factors might influence use of Section 2 or Section 3? Here are a couple of scenarios. They are fictitious, but describe situations that will be familiar to amps. Jason. It's 2200 hours on Friday evening. An out-of-hours amp is asked to assess a patient detained under Section 136. Jason is in York, where he was detained by police attempting to climb onto the altar of York Minster, claiming to be the second coming of Christ. The police have established that he normally lives in Cornwall, where he is well known to psychiatric services, has a diagnosis of paranoid schizophrenia, is subject to 117 aftercare, and recently went missing from the mental health hostel in which he was living. On assessment, it's clear that Jason is thought disordered, but is unable or unwilling to reveal any information about his medication or mental health care. It's clear that he needs to be in hospital. Unfortunately, the AMP is unable to contact mental health services in Jason's area to obtain more information. Should Jason be detained under Section 2 or Section 3? Applying the principles for decision-making in the Code of Practice, the AMP is aware that Jason is well known to his local mental health services and has in the past been detained under Section 3. But at the same time, the AMP is unable to confirm this and discuss the situation with Jason's care team. Because he is so far from home, neither the AMP nor the doctors assessing him have had any previous acquaintance with the patient. The AMP might, in these circumstances, consider that Section 2 is preferable, even though Jason's diagnosis and presumably treatment is well known. It is just that these things are not well known to the assessing team. Jonathan. Jonathan is a well-known patient with a diagnosis of bipolar affective disorder. He has recently stopped taking his mood-stabilising medication, and his care coordinator reports that he is becoming increasingly manic, spending profligately, not sleeping, is harassing his neighbours and becoming sexually disinhibited. These are all warning signs of relapse. An AMP and 2 Section 12 doctors assess Jonathan at home and conclude that he needs to be detained in hospital for treatment. The doctors have a dilemma. No hospital bed has been identified prior to the assessment, and the bed managers can give no indication as to how long it would be to identify a hospital where he can be admitted. What should the doctors do? The difficulty here is that, unlike medical recommendations of Section 2, the doctors have to state on a Section 3 recommendation the name or names of hospitals where appropriate treatment would be available. In the real world, where there is a national shortage of psychiatric beds, especially for children and people with learning disabilities, doctors will often make recommendations for Section 2 and then leave them with the AMP. These can then be used at any time within 14 days from the date of the recommendations. The doctors do not have to be involved in another assessment. But the doctors in Jonathan's case would not be able to complete their medical recommendations because they could not name the hospital in which the patient could receive treatment. So they can't just sign the document and go on their way. Might they be tempted to find some pretext that might justify detention under Section 2 for assessment rather than Section 3 for treatment? And would that be ethical? The nearest relative. The rights and powers of the nearest relative of a patient are important factors that AMPs have to take into account when considering detention under the Mental Health Act. For a Section 2, the nearest relative should at the least be informed that detention has taken place and should be made aware of their rights to order the discharge of the patient from hospital. However, for a Section 3, it is a legal requirement for the nearest relative to be consulted if at all possible, because if they object, detention under Section 3 cannot take place. The only option then for an AMP is to go to the courts to have the nearest relative displaced. This can be a time-consuming process, and it can take weeks for the courts to make a final decision. This is where some interesting decisions might be taken to avoid consulting the nearest relative, especially if it is known that they are likely to object to detention under Section 3. There's a body of case law relating to the nearest relative and failure to consult them. Sometimes AMPs and ASWs in the past have got into considerable trouble. One example is GD versus the managers of the Dennis Scott Unit at Edgware Community Hospital and the London Borough of Barnet, 27th of June 2008. Case law has some snappy titles. In this case, there were real fears that the patient's father might hide the patient if it was known that an assessment under the Mental Health Act was going to take place. The ASW did not contact the nearest relative before the assessment and only let him know by leaving a message when the assessment was actually taking place. When the nearest relative returned the call 20 minutes later, the paperwork had already been completed. He then indicated in no unclear terms his feelings about this and his objection. But the ASW had by then filled in the section of the form indicating that it had been impracticable to consult with the nearest relative. The judge in the case found that the patient had been illegally detained because the ASW had deliberately failed to make adequate attempts to consult with the nearest relative, as he knew that the nearest relative would object. An AMP may therefore be confronted with a dilemma. The AMP might be clear that a certain patient in the community who is well known to services with a clear diagnosis and where it is known what treatment the patient requires needs to be detained for treatment under Section 3. But the AMP is also aware that the nearest relative may object, making it impossible to ensure their admission and treatment, at least without having to go to a judge to have the nearest relative displaced. So, does the AMP bite the bullet, make efforts to consult, then go through the necessary legal processes if the nearest relative objects, even if this might put the patient in danger? Or does this hypothetical AMP consider that just maybe they can find some justification for detention under Section 2 for assessment, hence avoiding the need to obtain the nearest relative's consent, and at the same time ensuring the patient's safety?